Hi, it's Connecticut attorney Ryan McKeen here. I'm going to talk about how we got our $100 million verdict, highest bodily injury verdict in the state of Connecticut. And this video might be a little bit longer than some, but I'm going to try to give you an overview. It's going to be, Cliff Notes version, obviously, because it took us over 5 years to get that verdict. And going to walk you through, I think, some of the key decisions, some of the key things that we were able to do that I think made a lot of difference. And, really all credit goes to the team here. My partner, Andrew Garza, was lead counsel, and, we had attorney Andrew Ranks, attorney Alexa Mahoney, great paralegal staff who worked this. So by no means is it just me. I just happened to be along for the ride for 5 years and occasionally took the wheel. I think the very first thing that happened is, we were able to get involved in the case pretty early, probably about 10 days after the accident. And that enabled us to send out preservation letters so we could preserve some video footage. We tried to preserve some of the evidence, but that was already gone. We were able to start developing a witness list. We were able to start helping our client. We were able to start learning about our client's family and our client's values, which were tremendously important, 5 years down the road, as we were able to tell his story and really his family story, because we were there, so quickly. When we had some idea, we were able to request, police reports, OSHA reports, and get some of that information back. We were able to start talking with experts and start identifying what some of these issues may be in the case, or whether or not we had claims, or what was going on in a more general sense, because we didn't have all the evidence, but we wanted to know if what we had thought through our research was true. So we started engaging experts. We started talking to people right away. We started getting the information that we could get. We also sent letters out to companies and insurance companies, and they didn't actually respond to us, which resulted in us going out and filing a PJR, seeking to attach assets of these companies, which did get their attention. They did then retain counsel, and we began a real methodical, formal investigation that would go on really for about 4.5 years. First, there was the initial written discovery that we had to do to get all of our clients' medical records, wage records, pictures that we had over to the defense, get some basic stuff over from them, get that reviewed by our experts, and begin really sort of understanding in very granular detail what it is that was happening in this case. And I think it was probably 3-4 months after that we started taking depositions. There were close to 40 depositions taken of, fact witnesses, of employees, of coworkers, of the parties themselves, of experts in this case. So we started taking, depositions of fact witnesses in particular, to really try to understand what some policies were, what some procedures were, in the case. And you don't just get a $100 million verdict. It is a ton of work, because we knew that we could leave no stone unturned if we were to get the result that we really wanted to get for our client. We had to know the case better than any of the defense lawyers on the other side. And I think ultimately we did, and that was a big factor in prevailing in trial. My partner Andrew was tracking, shipping receipts and bills of lading to really get down to, what truck this load of lamps came in on, and getting real in the weeds on some of these details. We also did site inspections, which proved to be critical. We did site inspections of both the warehouse where the incident happened and the shipping facility of one of the defendants, Philip Signify, their warehouse, to see what their processes were, what their equipment were. We were accompanied by an expert. One of our experts was probably the top shipping and packaging expert in the country. He had actually been retained by Philip Signify as a consultant some years prior. He did not have a non-disclosure agreement with them, so he was able to work with us and give us, some really great insight into their policies and procedures. So we were able to really get comfortable with the idea of that we had a strong liability case, despite the defendants, saying that they had no responsibility. We didn't understand it. It didn't add up from anything that we had read or learned. Um, and they filed motions for summary judgment, which they wanted to take the case away from the jury. We fought those motions. And then we really began in earnest about a year ago, starting to march forward to trial. And that involved doing a number of focus groups for us to be able to understand what exactly had happened. That involved us prepping animations with expert animators, consulting with our experts to make sure that we could show the jury what had happened. That involved us. I had interviewed about 40 damage witnesses to talk about our clients, to talk about what had been lost, about who they were. So that way, when we headed into trial, I could pull 6, 7 of them, 8 of them, based upon maybe who was in the jury pool. And when we had good ideas as to what our themes were going to be of the trial. So we had that in our pocket. We spent an immense amount of time. We had 2 plaintiffs preparing our plaintiffs for testimony. It's very nerve-wracking, especially when you're a private person like our clients are, to have to show up in court and discuss some really intimate and awful things as they so bravely did. So we spent a lot of time preparing them for testimony. And we spent a lot of time focus grouping and trying to understand how a jury may perceive the evidence we were presenting, what the jury needed to know so that we could give that to them in a very concise and orderly fashion. And we really pressed forward on the strong points of the case that we had, which is that really the defendants violated their own safety rules, clearly did, and it caused the injuries. And our client had a vibrant life that was in many ways taken from him that day. We interviewed the doctors to talk about what his future would be, about what his future. We had experts for economic loss to talk about what he would need in the future, a life care planner, what that would cost in the future. So we were able to present a very clear and clean case to a jury, which we had to do because the only offer that we ever had from the defendant, or the ultimate defendant in this case, which was Philip Signify, was $1.5 million. And so we knew that the claim was worth much more than that. We were willing to accept $20 million, but they were never going to pay that. So we knew we had to take it. We knew we had to get justice from a jury because they weren't going to give that to us. And of course, in trial, every day involved just, hours and hours and hours of preparation, even the day before, because of, what kind of shenanigans the defense was going to pull that day to alert the judge, making sure that we had our legal arguments in order, consulting with appellate counsel because we knew we were going to beat them, and we knew we were going to get a good verdict, but we also knew that they were, they're going to appeal it. So we wanted to work with appellate counsel there, and all of this over 5 years, really resulted in a verdict that was in fact justice for our clients. There's a lot of nuance. This is sort of a long and short version of what it is that we did. But I'm immensely proud of the work that our firm did in this case. A verdict like this does not happen by accident. We, throughout the trial, throughout the case, We vetted this case and roundtabled it with some of the best plaintiffs' lawyers in the country, some of the best defense attorneys in the country. We even hired a retired judge to come in to consult with us to tell us what it is that we needed to know, because you know, it takes a whole village to achieve a result like this. And part of the challenge was, frankly, assembling the team of people necessary with the necessary expertise to deliver it, and then executing on that work. So, long story short is it's really doing the right thing, finding the right people, knowing what it is that you're doing, knowing what it is that's important, and going out there. Nothing beats doing the work and presenting your story, and trusting in the jury process. And that's what we did. That's how we got $100 million verdict.